Good day, Crime Talk aficionados. I hope you had a great weekend. It is Monday, June 9th, and we have a great show for you. First, Lori Vallow's appeal has been filed in her case in Idaho. She has some pretty good arguments. Lori Vallow also kicks out of the courtroom last Friday. Wait until you see this exchange with the judge. Police search for the suspect in Washington state, the triple homicide. His 3 young daughters. We have an update on the Sean Combs trial from today. Kierny starts day 29. I think we're getting close to the end. Aiden Kierny, a.k.a. TurtleBoy, a Karen Reed superfan, starts one of his trials today, and he waived a jury. The Gilgo Beach accused murderer, Rex Huerman, has his ex-wife in his support group now. This day in legal history, our quote of the day deals with prosecutorial misconduct. And finally, our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell for notifications of when we go live or put up new content. And remember, you can check us out on any of your favorite podcasting apps. Now, before we get to the docket today, let me remind you to go to CrimeTalkSearch.com and sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone here in the United States. The results literally prepared while you wait, and you get the report emailed to you. It's going to have all types of information about somebody you may want to know a little bit more about. Maybe you're just not getting that warm, fuzzy feeling. Maybe it's somebody new coming not only into your life, but your children's life. Want to check out that new boyfriend or girlfriend? Well, you can check out phone numbers associated with them, email addresses, their social media presence. You can find out if they have liens against them. Are they married? Are they divorced? Do they have a criminal history? That's a big one, right? And do they have to put themselves on one of those public registries? Things you may want to find out that, well, maybe they're not going to tell you because it's a little embarrassing. So go find out for yourself. Information is power. CrimeTalkSearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for June 9th, 2025. And first on the docket, the appeal has been filed by Lori Noreen Vallow, in her case in Idaho Supreme Court. And she challenges her convictions for the 2 counts of first-degree murder, 3 counts of conspiracy to commit first-degree murder, and grand theft, and 1 count of grand theft as well. Now, the brief presents 5 issues on appeal, each asserting violations of constitutional or statutory rights that allegedly tainted the fairness of her trial. So let me give you a summary of each argument and the basis for each of the argument outlined in the brief. All right, first of the arguments is deprivation of Sixth Amendment right to counsel of choice. What is Lori saying? Well, she's saying that she was deprived of her Sixth Amendment right to counsel of choice when the district court disqualified her attorney. Remember, Mark Means, based on alleged conflict of interest. Now, the legal standard for the Sixth Amendment guarantees the defendant a right to hire counsel of their choice, a fundamental right grounded in the need for trust and confidence in the attorney-client relationships. Well, the disqualification is a measure of last resort, permissible only with a showing of serious potential of conflict. Now, the state moved forward to qualify Mr. Means due to his brief representation of both Lori Vallow and Chad Daybell before Chad was charged. Now, the district court granted the motion, focusing on Chad's right to conflict-free counsel while ignoring Lori's right to counsel of her choice. Now, both defendants had waived any potential conflict in writing, and Chad confirmed he shared no confidential information with Mr. Means. Lori's arguing that the court abused its discretion by failing to balance Lori's fundamental right against the speculative conflict, relying on insufficient evidence of an actual or serious potential conflict, as Mr. Means' representation of Chad was brief, pre-charge, pre-filing, and end of over a year before the issue arose. Conducting the hearing in Chad's case while Lori was incompetent and unrepresented exacerbated the procedural flaws, she argues. And she says that the deprivation of counsel of choice is a structural error requiring reversal without a prejudice inquiry. So next, the deprivation of Sixth Amendment right to assistance of counsel during pretrial hearings. Like I said, Lori was deprived of her Sixth Amendment right to counsel during pretrial hearings on the state's motion to disqualify her attorney, where nobody was represented, as the district court denied her attorney's request to participate. The Sixth Amendment guarantees counsel at all critical stages of the prosecution, defined as stages where substantial rights may be affected. And the denial of counsel at critical stage is a structural error, according to the United States Supreme Court. So the hearing on Means disqualifications, like I said, was held under Chad's case number, while Lori's case was stayed due to her being declared incompetent. Means' motion to intervene and to participate in that hearing was denied, and it was construed as seeking a party status rather than participation to protect Lori's interest for her right to an attorney. Thus, Lori Vallow was unrepresented during these hearings, which directly impacted her right to counsel of choice. What was the legal error? The court's denial of Means participation violated Lori's rights to counsel at a critical stage of the hearing. It's like being invited to a party. It's your party and everybody's talking about you, but nobody will talk to you, I guess. Anyway, the error is reviewed under a fundamental error doctrine, and as Means did not explicitly cite the Sixth Amendment, but objected to proceeding without representation. The record shows no tactical the record shows no tactical reason for failing to raise the constitutional claims, and the absence of counsel rendered the proceedings unreliable, necessitating a reversal of the case. Now, throughout the brief that I have here, and I've read some 69 pages of it, a lot of things, well, let's just say they were waived by trial counsel. They didn't object. How many times have we talked about it? You got to object. Even though, you may not like it in front of the judge gets upset with you. The jury doesn't like it when you're objecting. Well, guess what? When you don't object, it is deemed waived. Now, I think the right to counsel, certainly a legitimate issue. It wasn't even the issue of Means being disqualified, who, frankly had no right being there. If you may recall, he was basically a divorce attorney who had never handled a felony case. And all of a sudden he was going to be catapulted to a death penalty case. I think the court was trying to protect Mr. Means and his client from himself due to complete lack of experience. But guess what? You, as an individual, have a right to counsel of your choice. If you wanted me to do a mergers and acquisition for a multi-billion-dollar publicly traded company, I would have no experience in that. I could probably Google it, right? But I'm probably going to be committing malpractice at that particular point. So it's best to get somebody with some real experience. It's best to get somebody with some real experience on your case. But if you wanted to hire me for that, even if I told you I'm not qualified, you could still say, no, Scott, you're my guy. And that's allowed under the Constitution. So it'll be an interesting issue. Obviously, we need to see what arguments the prosecution will make, the state will make on the appeal. I'm sure it will be, hey, this was waived, and why are we revisiting this whatsoever? It's an abuse of discretion standard, so we'll have to wait and see. Next, the argument is deprivation of the 14th Amendment due process rights. All right. So what's the argument being made here? Well, Lori was deprived of her 14th Amendment due process rights when the district court held pretrial hearings on the disqualification motion in her absence and while she was incompetent. So the due process prohibits prosecution of an incompetent defendant and guarantees a defendant's presence at critical stages where the presence contributes to fairness. These rights are protected under the 14th Amendment when not tied to the Confrontation Clause. So the disqualification hearing occurred while Lori was incompetent and in a state hospital with her case that was completely stayed. Nothing could take place on it. All right. She was not present, and the court proceeded in Chad's case, ignoring her rights. Now, Means, like I said, he did object to the proceedings during the stay, but did not cite the 14th Amendment. So the question is it waived? The court The error that Vallow raises is the court violated the due process by litigating a matter affecting Lori's rights during her incompetence and absence. This review is a fundamental error, and the error is clear, they argue, as Lori could not waive her rights and means objected to the stay indicates no tactical decision to forego the claim. Obviously, the significant impact here is the combined absence of Lori Vallow herself and her counsel undermines the fairness of the proceedings. Now, the next one, error in admitting uncharged misconduct. Now, this is the one I said, this is going to be a good one. All right. I like the, Judge, you screwed up. You did something without her presence. You got rid of her attorney without inquiring of her, without having a hearing in her case. Interesting issues indeed. But this is the one I think that will probably, if it gets reversed, they all could. We'll have to wait and see. And don't get me wrong, I'm no fan of Lori Vallow at all, but we want to make sure that her rights are protected, like anybody, right? What's the old adage that if we let them start railroading guilty people, they'll start doing it to innocent people as well. And that's what defense attorneys are supposed to protect. Not just the client's rights, but they're protecting everybody's rights under the Constitution. All right, error in admitting uncharged bad acts under 404B evidence. The argument is that the district court erred by allowing the state to introduce extensive uncharged bad acts evidence from Arizona under the Idaho rules of evidence, which prejudiced Lori's trial. So the legal standard 404B evidence prohibits evidence of prior bad acts to prove propensity, but allows it to show purpose, plan, preparation, knowledge, or identity if reasonable notice is given. The evidence first must be relevant, supported by sufficient facts. Its probative value must not be substantially outweighed by the unfair prejudice, and the state introduces evidence of Charles Vallow's shooting and the attempted shooting of Brandon Boudreaux among the other Arizona cases, claiming that they showed plan, preparation, knowledge, or identity. The initial notice filed 8 weeks before trial was very broad, and Vallow's attorneys objected to the late notice and the evidence's relevance and the prejudicial impact. Now, what have we talked about before in 404B evidence? The courts are finally getting to the point where it has to be narrowly tailored. You can't just show it all. It's not propensity, Judge. It's motive, operandi, identity, plan, scheme, absence of mistake. It's all those, Judge. No, you have to be able to identify which specific one, not all of them, which specific one. I said that at the time. When the prosecution starts getting into 404B evidence, you know their case is weak. And when they can't particularly articulate that particular issue, well, it's weak as well. And obviously the appellate attorneys are arguing that there's no relevance. The Arizona evidence lacked distinctive characteristics to prove identity or knowledge and was not sufficiently tied to a plan or preparation for the Idaho crimes, and that this resulted in unfair prejudice. The extensive evidence, testimony from 19 of the 60 witnesses created mini trials, risking jury confusion and propensity-based convictions with prejudice outweighing its potential probative value, citing Rule 403. And they're saying that the court abused its discretion and the prejudicial effect likely influenced the jury's verdict, requiring a reversal. Next argument, violation of statutory and constitutional speedy trial rights. I thought this was probably one of her best arguments. So the argument on appeal is the district court erred in denying Lori Vallow's motion to dismiss for violation of her statutory rights under Idaho Code Section 193501 and the constitutional speedy trial rights due to a 2-year delay between indictment and trial. So what's the legal standard here? The Sixth Amendment and the Idaho Constitution guarantees a speedy trial assessed via the Barker v. Wingo 4-factor test. Length of the delay, reason for the delay, defendant's assertion of the rights, as well as prejudice. The statute in Idaho, 1935-01, mandates trial within 6 months of arraignment unless good cause is shown. Well, the state indicted Lori in May of 2021, but her trial began in April of 2023. Now, there's a 2-year delay. Lori consistently demanded a speedy trial, objected to any continuance, and delays include a 10-month competency restoration period, which obviously isn't counted. And then they have the state requested continuance to align with Chad's trial and a defense requested competency reevaluation, which was opposed by Lori Vallow. So what are they arguing? They're saying that the delay exceeded 6 months and the court's findings of good cause was unsupported as the reasons, competency, case alignment, did not justify the extent of the delay given Lori's strong assertion of her rights. What's the big deal? Well, the Barker factors, which I noted a moment ago, favor Lori Vallow. The 2-year delay was presumptively prejudicial, according to State v. Mansfield, 559 P. 3rd, 1177, an Idaho case decided in 2024, Idaho Supreme Court to be exact. And the reasons for the delay were neutral or state-driven. Lori vigorously asserted her right, and the prejudice arose from prolonged incarceration and anxiety under the threat of a potential death penalty. The court erred, is what they say, in denying the dismissal, and the violation warrants reversal with the instructions to dismiss the indictment. So, like I said, she seeks reversal and ultimately dismissal of all charges based upon the speedy trial violation. Alternatively, she requests reversal and a new trial due to violation of her Sixth Amendment right to counsel and choice of assistance to counsel, as well as the erroneous admission of prejudicial 404B evidence. Each issue is grounded in constitutional and statutory protections supported by case law and tied to specific procedural and substantive errors in the district court handling the case. So, very good brief. I must note the attorneys for Lori Vallow, Craig Durham, he did a really good job for Lori Vallow. I liked how he constitutionalized all of the arguments, even though there's some issues of waiver by the trial counsel. But when you start getting into the speedy trial stuff, this is actually a pretty good case for this. Even if you exempt out that 10-month time for competency, her trial wasn't within that time period. And she demanded speedy trial. She never let speedy trial go. In fact, that was one of the reasons why the death penalty was ultimately dismissed against Lori Vallow, because she demanded speedy trial. There were discovery violations by the prosecution, and the judge had to impose a sanction. So he removed the death penalty. Will she get a new trial? I don't know. I really don't know. They've made some very good arguments in this case, but guess what? The prosecution is going to get to file their brief, and then there will be a reply brief. I'm sure most of the prosecution's arguments are going to be, you waived it at the trial court level, therefore it's a plain error standard, which is so obvious that the judge wouldn't do it. We'll see. It's kind of one of those things. It's just the whole thing. It was a weird case. You had a judge that wasn't that experienced in criminal law as it related to a lot of these issues, seemed overwhelmed. So much of it was done in secrecy, which I have a big problem with. And on top of that, like I said, I'm no fan of Lori Vallow. I think she's a horrible human being based upon the convictions that she's got. But I did note that those were all appellate issues. If you went back and looked at my old videos, and I'm not going to go have Frank go find them, but I said speedy trial, 404B were going to be the issues that this case comes back on. Now, what would the appellate courts do, right? They could deny everything. They got to do some legal gymnastics. Remember, this is going to be a published case. So they got to make sure, hey, we're setting precedent here for everybody that comes after Lori Vallow. So they can't just use the son of a gun rule, which is, well, she's just a big son of a gun. And, let's find, although there was error, it was harmless, move along. I think they're going to have a little more difficult time to get there on that. So like I said, it's going to be interesting to see. Obviously, we'll wait for the prosecution's brief in response, and then a reply brief by Lori Vallow through her attorney, Craig Durham. But it's going to be interesting, ladies and gentlemen. It's going to be very, very interesting. And maybe I'll do a show where literally we go through, not this, but I'll put it up. We'll just read it verbatim, and you can read for yourself or listen for yourself what it is. But anyway, what else is going on with Lori Vallow? Well, she's got her second trial in Arizona. And that trial of Lori Lori Vallow, continues today, starts about noon. We'll bring it to you live. And it is accused that Vallow's allegedly tried to kill her ex-nephew-in-law, Brandon Boudreaux. And he also took the stand last week. Anyway, Daybell briefly was removed from the courtroom after a little bit of an exchange with the judge. She's accused of conspiring, obviously, with her late brother, Alex Cox, in an attempt to have him killed. Boudreaux was shot at outside of his home in Gilbert, Arizona, back in October of 2019. And while Boudreaux was not hit, the incident is linked to a series of deadly events in Idaho, including the murders of J.J. Vallow and Tylee Daybell. And let's not forget Chad Daybell's first wife, Tammy. Anyway, back in April of 2025, Vallow was also found guilty of plotting the fatal shooting of her fourth husband, Charles Vallow, there in Chandler, Arizona. And just like she did in her first Arizona trial, Ms. Vallow is representing herself as well.
You can come in. If I open the door, do I get a hearing? We stop trial and I get a hearing
Stop. We'll have a very short hearing, okay? If you're going to introduce how you have great character and good character, we're going to have a short hearing on what evidence that they can bring in to rebut that character, which could include being convicted of 4 murders.
And
So
would you
talk
like...
to your advisory counsel during the break. And
You don't need to yell at me either.
yelling at you, okay?
Yeah, you are. And you do not need to talk to me that way. I'm
Take
very
her out.
courteous.
Take her out.
I'm very courteous to you.
Take her out. No, you have been nothing near courteous to me during the course of these proceedings. Talk with your advisory counsel about the rest of your cross. We're going to resume in 15 minutes.
All right.
We'll see how that goes for her. Maybe, obviously, she's going to probably get life on the death of Charles Vallow. And if she gets a lengthy sentence here, the appellate court may feel a little more comfortable saying, hey, give her a new trial. I don't know. They're going to have to do some legal gymnastics on that speedy trial argument. We'll just have to wait and see. But remember, the defense attorneys didn't really argue the speedy trial argument. I was more saying, argue speedy trial. But it's like they wanted it because they weren't ready. I tell you, man, those big cases like that, particularly if your clients, let's just say, won't be taking the stand, sometimes all you got is ready, set, go. And some of the best results I've ever got from homicide trials is when we went on the first setting, because the prosecution always expects you to continue the first setting. No murder trial goes on a first setting. Mine do. Next, police continue to search for the suspect in the Washington State triple homicide. That's right. The sheriff's office up there is actively searching for Travis Decker, a 32-year-old former Army veteran wanted for the murders of his 3 daughters, Peyton, who's 9, Evelyn, 8, and Olivia, who is only 5. Now, the investigation began back on May 30th when the girls did not return home following a scheduled visit with Decker. Then on June 2nd of this year, their bodies were found at a campsite in Leavenworth, Washington, approximately 20 miles from their residence. Autopsy revealed the victims had all been bound with zip ties and suffocated with plastic bags. Decker now faces 3 counts each of first-degree murder and first-degree kidnapping. Police have described him as dangerous, potentially armed, and possessing extensive military training in navigation, survival, and long-distance movement in rugged terrain. The affidavit for arrest warrant notes that Decker's history of outdoor activities, including hiking, camping, hunting, and a 2.5-month period living off-grid in remote areas, for that reason why they consider him dangerous. Then on June 7th, the sheriff's office released updated images of Decker depicting him wearing a tan shirt with the number 59 on the sleeve, dark shorts, flip-flops, and carrying a pizza box with his hair tied back. The image also highlights very distinct tattoo on the arms and ankles, and a wanted poster advises the public not to approach Mr. Decker and to contact 911 immediately if they see him. Investigators have uncovered evidence suggesting Decker may have been attempting to flee to Canada, and search warrants for his Google account revealed queries back in May of this year, May 26 to be exact, including how does a person move to Canada, how to relocate to Canada, and jobs in Canada, as well as a visit to the website Find a Job. Canada.ca. Now, the campsite where the victims were found is approximately 11 miles from the Pacific Crest Trail, a route leading to the Canadian border. Now, the sheriff's office has concluded roadblocks and large-scale searches of structures and forested areas, but continues to seek public assistance. Residents are urged to review doorbell and security camera footage for sighting Decker and to report any suspicious findings in any recreational areas, noting the time and location. Tragic case. Who could kill their own kids? Absolutely horrific. Doesn't appear to be a whodunit, but obviously you still got to give him the presumption of innocence until he pleads guilty or is convicted by a jury of his peers. Next on the docket, a quick update on the Sean P. Did He Do It Combs trial. That's right, fifth week. So the federal trial of Sean Combs, charged with sex trafficking and racketeering, has entered its fifth week at the federal courthouse there in Manhattan. The proceedings, presided over by U.S. District Court Judge Aaron Submanian, featured some significant testimony from a key witness identified only as Jane, and the introduction of disturbing voice notes and text messages. Now, Combs faces life imprisonment if he's ultimately convicted of orchestrating a criminal enterprise that allegedly coerced women into sexual activities over 2 decades. So let's give you a quick summary of what took place today. Jane, an ex-girlfriend testifying under a pseudonym. Anyway, Jane began dating Combs back in 2020. She continued her testimony from last week, detailing a pattern of coercion and emotional manipulation. She recounted being pressured into participating in freak-offs, which were sexual encounters with male escorts orchestrated by Mr. Combs, which she said she undertook to please him. Despite her discomfort, Jane testified that Combs provided her with a $10,000 a month allowance starting back in April of 2023 to cover her Los Angeles rent, which he used as leverage to ensure her compliance. She described an October 2023 incident where, after vomiting during a hotel night and attempting a drug-free encounter, Combs insisted she continue with a third male escort. Jane also testified about smuggling drugs for Combs on 2 commercial flights from Los Angeles to Miami at the behest of the Chief of Staff, Christina Courtroom, despite her unease. Now, prosecutors presented a 2023 voice note in which Combs told Jane to get on her job after she declined a freak-off, warning of a rude awakening and threatening to withdraw financial support. There were text messages from September and October of 2023 that showed Jane pleading with Combs, stating, "I'm not a porn star. I'm not an animal," and expressing exhaustion from 3 years of coerced sexual encounters. In a recorded phone call following Cassie Ventura's 2023 lawsuit against Combs, Jane was heard sobbing as Combs claimed their kinky activities were mutual, urging her to support him. Jane told the jury that reading Ventura's lawsuit felt like reading my own story, causing her to nearly faint from shock and sympathy. Now, the defense had not yet cross-examined Jane by the time we recorded this today. However, we'll bring it to you tomorrow, and we'll see where it goes from there. I don't know. It's starting to see a bit of a pattern there. I'm not saying it's going to be enough for the jury to be convinced, but it's certainly maybe enough for the jury to think, wow, this seems to happen over and over again with all the people that Mr. Combs hangs out with. He pays them lots of money, pressures them to do things they don't want to do. But does it, like I said, is it weird? Is it kinky? I mean, there's probably lots of people out there that have their little side piece like Mr. Combs did, right? And they take care of their apartments and buy them things, right? But is it criminal conduct? I mean, that's really the defense in this particular case. Is it criminal conduct? Now, remember, in a racketeering, you got to show a couple of predicate acts, right? And you got to show 2 of those events occurred. And if those events occurred, then you get the pattern of racketeering activity. We'll see. We'll see whether it's going to be enough. Next on the docket, the Karen Reed trial continues. All right. So what has taken place today by noon when they broke for lunch? First, like I said, the Karen Reed trial progressed with another pivotal testimony and a significant defense motion for a mistrial. Now, Karen Reed, for those who don't know, is charged with striking her boyfriend, then Boston police officer John O'Keefe, with her SUV back in January of 2022 and leaving him to die in a snowbank outside of a house party at 34 Fairview Road, Canton, Massachusetts. Now, the defense contends that Reed was framed in a complete conspiracy and that O'Keefe was beaten by another officer at the party. Now, a prior trial ended back in 2024 due to a deadlocked jury. Now, I should note that the defense has kind of backed off from that, and now we're gone to dog bites, and the accident never happened, but there's been no direct evidence of John O'Keefe going inside the house and being assaulted in any way whatsoever. Not even a denial of that, because none of the witnesses have testified to that. So what happened today? First, Judge Kierny opened the session by addressing motions. The prosecution's motion to call rebuttal witnesses to counter the defense's dog bite and crash reconstruction expert was granted. Now remember, the prosecution wasn't allowed to present in their case in chief their dog bite expert. But now that the defense has raised that issue, the prosecution then gets to call their witness in rebuttal. Now, there was also a motion to delimit defense witness Andrew Rentschler's testimony that was put off by the judge, and a voir dire of defense witness Dr. Elizabeth La Posada was scheduled right before they took the break regarding her testimony on dog bites. She is a doctor, medical examiner, and apparently has done lots of dog bite cases. During the voir dire, she could not talk about any specific dog bite cases. She's been qualified once in a dog bite case, but it doesn't sound like it was a death case. So we'll see. I mean, this is fine. Let the truth get out there and let the jury decide. All right. Anyway, so first we had Daniel Wolf's testimony continue. He's the defense crash reconstruction expert from ARCA, and he continued his testimony detailing the 29 per mile crash test using the Rescue Randy dummy to simulate Mr. O'Keefe's injuries. Now, photos showed road rash and clothing damage supporting the defense claim of no vehicular collision. And the prosecution's cross-examination challenges Wolf's credentials and the dummy validity, leading to an contentious exchange and sidebar. Then the defense moved for mistrial with prejudice, alleging that the special prosecutor, Hank Brennan, intentionally tried to mislead the jury by displaying O'Keefe's sweatshirt with holes cut by the criminalists when they were doing their testing, suggesting they resulted from a collision. Brennan, apparently not recalling that those were cuts from the criminalists, take it what you will, said, you know what? You're right. I made a mistake, and a mistrial is an extreme sanction, should not be the course of action. Give a limiting instruction and let's move on. The judge agreed, denied the motion for mistrial, and actually read an instruction to the jury that the holes were made during a criminalist inspection back in May of 2023, not from the incident in 2022. Then the defense was going to call an investigator, John Tedman, who testified about measurements and photographs taken at the crime scene on June 3rd of 2025 after being hired due to another investigator's health issues. On redirect, Dr. Wolf explained kinetic energy equations to support his analysis, and obviously that was to refute the prosecution's collision theory and to suggest alternative causes for Mr. O'Keefe's injury. On, like I said, cross-examination, Brennan questions Wolf's expertise, the use of Rescue Randy as the crash test dummy, and potential new information received from the defense. The prosecution aimed, obviously, to undermine the reliability of Wolf's reconstruction efforts and to reinforce the theory that Reed struck O'Keefe with her SUV, causing his death. Now, the private investigator provided measurements and photographs from 34 Fairview Road to support the defense crime scene analysis to bolster the defense investigation, though limited by its late involvement. Now, like I said, defense attorney Alessi argued that Brennan's presentation of O'Keefe's sweatshirt with the criminalists making the holes as collision evidence was intentional misconduct, prejudicing the jury on the core of the issue of whether a collision occurred. And Brennan acknowledged the error and suggested a curative instruction, which the judge did. I get it. I've moved for mistrials. Judge, I demand a mistrial. Oh. And Mr. Alessi, he was using the courtroom theatrics today. Put the gloves on to hold up the sweatshirt, you name it. I was like, I'm watching, I'm like, this is going to be denied. Totally going to be denied. Let them cross-examine on it. Give them time to redirect. Bring in the witness. But they came to a stipulation, thank God. So this trial may actually get done by sometime of, I don't know, July 2026. Just kidding. Hopefully it'll be done by the end of the week. So obviously the critical testimony from Mr. Wolf challenging the prosecution's collision narrative and the heated mistrial motion over the sweatshirt evidence resolved by a judicial instruction. Then right before the break. Dr. LaPosada's testimony indicating the ongoing, obviously, intensity as the trial approaches a potential final week. We'll see. I think Dr. LaPosada will get to testify. Now, remember, I haven't seen the ruling because this is over the lunch break and I'm doing this video right now. But I think she will testify, but the judge will probably limit some of her scope of testimony. Let's watch together and see if I'm correct. And next, let's talk about Aiden Kierny. That's right, the ultimate Karen Reed fanboy, known online as TurtleBoy, is a controversial Massachusetts blogger who operates the website TB Daily, and he has gained some significant attention for his extensive coverage of the Karen Reed murder case, in which obviously Miss Reed is accused of murder. Now, Kierny has been a vocal supporter of Miss Reed, promoting a narrative that she was framed as part of a cover-up involving law enforcement and other parties. His coverage has included live streams, blog posts, and public demonstrations, which have attracted a large following, but also controversy. Now, why is Aiden Kierny even on trial? Well, he's facing multiple legal challenges primarily related to allegations of witness intimidation in connection with the Karen Reed case, as well as charges stemming from separate incidents involving a restraining order violation. Scheduled court appearance today before Judge Michael Pamaroli concerns his misdemeanor charge of violation of the protection orders. This charge stems from the alleged incident back in February of 2024, where Kierny's ex-girlfriend, who had a restraining order against him, claimed he yelled at her outside the Norfolk Superior Court during a Karen Reed hearing. Now, Kierny denies these allegations, and his attorney has argued that the encounter was engineered and that the evidence included video and affidavit supported Kierny's claim that he did not shout at her. So he also faces separate felony charges of witness intimidation related to his alleged actions towards witnesses in the Karen Reed case. Prosecutors claim he was harassing and intimidating witnesses, including confronting them at their homes or businesses and publishing their contact information, which led to further harassment by his followers. These charges include an incident back in March of 2025 where Kierny allegedly spoke into a surveillance camera at a pizza shop owned by Chris Albert, a witness in the Reed case, accusing Albert's son of involvement in O'Keefe's death. Now, Kierny maintains that his actions are protected under the First Amendment, as well as journalistic activity, a position his attorney has consistently argued in court. And, well, guess what? Instead of having a jury trial, Mr. Kierny chose a bench trial where the judge and the judge alone decides the case without a jury. And that was Mr. Kierny's decision. And I actually saw a post that he put up this morning. They're going to do the trial over the next 2 days from 11 a.m. to 1 p.m. for the next 2 days. Now, is this some sort of brilliant strategic decision? Maybe. Maybe he and his attorney believe that the judge, as an experienced judge, is better equipped to evaluate the legal nuances of the case, particularly the First Amendment arguments central to Kierny's defense, and a judge may be less swayed by emotional appeals and the public sentiment compared to a jury. Perhaps that's the particular case. Also, it's efficient, right? Bench trials are typically faster than jury trials, and they eliminate the need for the jury selection and the deliberations and in and out and all that stuff, right? Now, have I had to do trials to the court? Yes. Do I like them? No. Because, let's face it, if you do have a criminal trial, you have to, the prosecution has to convince 12 people of somebody's guilt. Why would you have just one who's a judge? Now, they're good judges, and I've had judges. Usually our jury trials are municipal court cases. I think maybe once or twice a DUI or something years and years ago, thinking, it's technical defense. The judge will understand it better. Never again. Let the jury be confused, raise reasonable doubt. So, and I've had judges, find clients not guilty on a trial to the court. But for the most part, what they do is they find the defendant guilty, and then based upon kind of the mitigation that they hear in trial, they will reduce the punishment, so to speak. So I don't know if it was a good decision or bad. Only time will tell. But needless to say, Mr. Kierny, who's juggling multiple legal battles, as well as trying to cover the Karen Reed case, we'll have to wait and see. Anyway, yes, juries can be unpredictable, but judges usually are, and they usually find people guilty. So once again, don't necessarily agree, but hey, I'm not there. I don't have all the facts, so you got to defer to the judgment of the people on the ground, at least in this point. And then when we know more, we can maybe make some further analysis of what went wrong and, well, maybe what went right. We'll see. Maybe he'll be found not guilty. First Amendment covers lots of things. True threats do not. Restraining order violations, pretty straightforward, man. You just can't go there, right? You have a protection order. You can't communicate in any way. You can't send email. You can't say text. You can't yell. You can't say hi. You can't use carrier pigeons. You can't send smoke signals. You can't do anything. If you see the person, you need to walk the other way. You don't get to continue walking and say, well, I was here first. No, you turn around and walk away. Next on the docket, let's talk Gilgo Beach murderer. Asa Elrup defends her ex-husband Rex Heuermann in the Gilgo Beach case. That's right. Miss Elrup expressed support for her husband, Rex Heuermann, in an interview for the Peacock documentary series, The Gilgo Beach Killer, House of Secrets, which began airing on June 10th. Now, Heuermann, a Manhattan architect, was arrested last year, actually July of 2023. I'm sorry, I misspoke, and charged with the murder of 3 sex workers. Now, the Suffolk County prosecutor later added charges for the murder and mutilation of 4 additional sex workers whose bodies were found along the Ocean Parkway on Long Island over nearly the next 3 decades. So Elrup maintains that Heuermann is innocent, stating, "I know what bad men are capable of doing. Not my husband. You have the wrong man." She described Heuermann as a family man and denied allegations of his involvement in the crimes, citing his routine presence at home. Now, evidence presented by the prosecutors include DNA matches, such as hair links to Miss Elrup and the couple's daughter, Victoria, found at the crime scene. And Elrup met Heuermann at 18 while working as a Long Island 7-Eleven employee. They formed a platonic bond, later marrying in Sweden in 1995 after their first marriages ended. Their daughter, Victoria, was born in 1996, and Elrup filed for divorce after Heuermann's arrest, though Victoria stated in the documentary that the filing was to protect assets. Now, Elrup continues to communicate with Heuermann in custody, but expressed concerns about their conversations being recorded. Duh. Of course they are. Anyway, Elrup denied claims of the couple hosting swinger parties and stated she believes prostitution should be legal. She also questioned the ownership of pornographic materials found in their home, as cited by the prosecutors. Now, regarding Heuermann's daily routines, Elrup noted that she picked him up from the train station daily, and he spent his weekends at home. We'll see. I would think if she really want to help her husband, I know she's doing it for the money. She's getting paid for her participation in this docu-series. I get it. She has to survive. But those are the type of things that you probably want to save for trial, right? Just like we saw in the Karen Reed case. All those statements for any witness, not just the defendant, can be used against you, at least for impeachment purposes. And then they get to know what you're going to testify to if you testify. And then they get to go say, oh, well, remember this one time? Yeah, it didn't happen that way. He didn't go home. You were gone for the weekend. All those types of things. So it's best to save it for a surprise where they don't have time to prepare for it at trial. Next, this day in legal history, June 9th, 1861, federal authorities were prosecuting Confederate sympathizers for treason under the wartime laws influencing Civil War era civil liberty precedents. On June 9th, 1930, federal agents raided illegal speakeasies in Chicago, targeting once again organized crime, exposing corruption, and supporting prohibition eventual's repeal. On this date in 1969, June 9th, 1969, my goodness, coming up on 56 years ago, the Senate confirmed Warren Burger as Chief Justice of the Supreme Court, replacing Earl Warren. His tenure influenced key criminal justice rulings, including Furman v. Georgia. And on June 9th, 2020, after investigators uncovered the remains of Lori Vallow Daybell's children, Tylee Ryan and Joshua J.J. Vallow, on his property, for Chad Daybell's property, he was then taken into custody around 11:30 a.m. that day and booked into the Fremont County Jail on 2 felony counts of destruction or concealment of evidence. Obviously, those charges were later amended to include murder and conspiracy and robbery and all those other things. And guess what? That was the same day as Frank's first day here at Crime Talk. That was quite a day, wasn't it, Frank? Next, our legal quote of the day has to do with prosecutorial misconduct. Prosecutorial misconduct occurs when a prosecuting attorney oversteps the bounds of that propriety and fairness which should characterize the conduct of such an officer in the prosecution of a criminal offense. That is a cite to Berger v. United States, 1935. Ladies and gentlemen, nothing changes. The more things change, the more they stay the same. All the same issues, nothing changes. Like I said, I'm going to have to go to the library and see if I can't check out some old law books and just show you. It's the same old stuff, same issues, same crimes, just the methodology changes up a little bit. And finally, our dumb criminal of the day. In the world of dumb criminals, you never want to be dubbed the dumb criminal of the day. That obviously means you did something crazy or stupid to stand above all of the rest. Well, once again, a Florida man certainly seems to fit that description today. He was arrested for driving 104 in a 45 mile an hour speed area. And guess what? What did he say? What his reason was? He says he just likes the sound of his exhaust. And that's obviously not going to get him out of trouble. I'm not aware of it's a really cool sounding exhaust defense. Anyway, 18-year-old Daniel Labina Chow, I guess he's not a juvenile, he's 18, was the Florida teen arrested for going too fast in a Dodge Charger. He claimed he did it because he liked the noise of his exhaust. Hey, we've all been there, right? Anyway, in his defense, it can be a pretty cool sound. Let's all be fair. That doesn't mean you can go as fast as you want to on the roads. It's dangerous, especially when you reach those speeds. Needless to say, Mr. Chow was taken into custody and charged with street racing. Come on, haven't we all done that? Come on, haven't you all? You know, the old days, the exhaust pipes, it was great. Now you got to put it in sport mode instead of comfort mode. But it sounds like even though you got a V8 dual turbocharged 560 horsepower BMW engine, it sounds like a big block 396 or 454 with the pipes taken off. I've been there, Mr. Chow. I understand. You can't get caught. That's not advice to speed, ladies and gentlemen. Part of job as attorneys tell you where to draw the line. Stop there. 140, too fast. Unless you're on a race course. Anyway, that's all we have for today. Thanks for joining us. Remember, follow the Lori Vallow trial. We've got the Karen Reed trial. All right, thanks for watching. We'll see you next time. And remember, the Constitution matters.